Welcome back to Advocacy Alchemy with Professor Ross. I am Professor Ross, and today we're going to look at a short video dealing with a revocation. Alright, so this case takes place in Texas, and this is in front of Judge Boyd. This is a fairly new video, and I believe it's from this week. So let's start off by defining what is a revocation, and we'll look at the law in Texas. Now, I will say that I deal with criminal revocations quite a bit in my daily life. All right, so I'm fairly versed in what happens during a revocation in my home jurisdiction. And I'm pretty sure that it's fairly uniform state to state after listening to this video once. Let's start with some definitions. Texas law, criminal revocation. All right, so first of all, let's determine what a revocation is, okay? So revocations deal with a person's parole or probation. So apparently there had to have been some sort of violation to either their parole or their probation conditions. This says Texas parole and probation revocation process. In Texas, the process of revoking parole or probation involves several steps and legal protections for the accused person. Here are some of the key points. All right, due process is key. All right, first of all, due process is key throughout the whole American jurisprudence system. The American justice system revolves around due process, meaning that nothing's going to happen to a person without them first receiving the opportunity to respond back to any allegations. All right, so due process. You have hearing process, and you have graduated sanctions. All right, so it says the 1972 U.S. Supreme Court decision, Morrissey versus Brewer, established due process requirements for revoking parole. All right, so that's the main Supreme Court case that sort of established the process for revocations and things of that nature. All right, and actually that makes quite a bit of sense of why the process might be very uniform across the board in many of the jurisdictions out there. Let's talk about the hearing process. An offender is accused of violating parole conditions. They are entitled to a preliminary hearing unless the violation is administrative. All right. Or the offender has been convicted of a new crime. All right. The hearing officer determines if there is enough evidence to support the allegations. Graduated sanctions. The Texas Board of Pardons and Paroles uses graduated sanctions to reduce the number of offenders returning to prison for technical violations. Now, a technical violation could be something as simple as a person failed to inform their probation officer that they received a minor infraction, a misdemeanor, all right, within a certain period of time. Or it can be that they failed to obtain gainful employment or any of the other smaller conditions, not a new felony offense, but something small. They tested positive for alcohol, all right? Because when a person's on probation, in my home jurisdiction, you can't use alcohol or illicit drugs, okay? So if a person tests positive for alcohol, that's a technical violation of their probation, and a person could be subject to being revoked, meaning their probation is revoked, and they will have to go and serve their prison sentence, whether it be the full sentence or some newly determined sentence less than the original sentence. All right. All right. Some of the options in Texas are continuing the parole with additional conditions or referring the offender to a special facility. All right. If you've heard my videos in the past, we have, in my home jurisdiction, we have ADC, which is the Arkansas Department of Correction, and we have certain division or Department of Community Correction facilities, which means these are probation or probation supervised facilities, dormitory settings, low-level prisons, things of that nature. And they call it CCC here in my home jurisdiction. All right. Probation revocation. All right. This works much the same way here in my home jurisdiction. There'll be a petition to revoke in my home jurisdiction, but here they say a motion to revoke. All right. Motions and petitions are pretty much the same thing. All right. That means that the attorneys from one side or the other, when you have a petition, it basically means one side or another is moving to have the court look at their argument to see if their petition or their motion should be granted. A motion is the same thing as a petition. A motion is simply a filing requesting certain relief. All right? And that relief can either be granted or it can be denied. All right, it says this can lead to a hearing where the court determines if the offender violated the conditions. All right. At the hearing, the state presents evidence of the violation, and the offender can present their own evidence and arguments. The judge then decides whether to revoke probation and impose the original sentence or continue probation with additional conditions. All right. All right. So probation. Now, many times, in this case today is similar. Many times people are coming up on revocation hearings due to drug usage. All right. That's a major point in my home jurisdiction, and I'm sure it's fairly the point or the reason why people are revoked in many jurisdictions. Now, the key thing is, just like how they talked about here in Texas, they use graduated sanctions. It's because there's no room in prisons right now. There's no room in jails or prisons to hold people for small offenses. If you fill up your jails and your prisons with people who have minor offenses, then you don't have room for people that you really need to hold and incarcerate. People who have violent offenses, people who have very serious felonies. All right, so that's one of the things that the state and the counties have to weigh, whether to imprison people who have low-level violations or to let them remain out and see if they will do right if they're given another chance. All right, so with that initial portion, let's go ahead and we will take a look at the case from today. Okay, let's make this big. And once again, all shout outs go to We Got a Case, Court Watch. All right, this is a strict judge thinks defendant may be high in court. All right, this is during a plea involving a revocation. All right.
Court is calling 2018 CR 12057 State of Texas versus Jessica Decimito. Could I have parties announced for the record for the state?
Garahan, Your Honor.
Defense,
Roger Pettis for Ms. Decimito, Your Honor.
are you Ms. Decimito?
Yes, Your Honor.
I'm going to show you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Okay, notice that the name of the document was Notice to Revoke Community Supervision. All right, so usually that document is given out at the preliminary hearing. All right, you summon a person back to court, and then you read them what the charges potentially are and let them know exactly what the violations are. That's a part of due process, letting a person know exactly what their charges are and then allowing them to make the decision for themselves whether they want to attempt to fight those allegations or accept a plea and begin to handle their situation. All right? But everyone has a right to take their matters to court. I remember when I was in middle school and the very beginning of high school, there was that song that came out, "Take It to Trial," take that ish to trial, and it was quite popular back when I was, like I said, in junior high school and the very beginning of high school. All right, so let's jump back in. Let's see what they have to say. This is a short video, so we're going to let it play pretty much, but we'll be stopping and lecturing about a revocation because it's important that people understand what the revocation process is, because not everyone who's sentenced to prison goes to prison, or not everyone who's convicted of a crime, that's the better way to say that, not everyone who's convicted of a crime goes to prison. All right, some people are allowed to serve their sentence on supervised probation. All right, and some people who go to prison don't serve their full time. They may make parole, which means they'll be transferred into a different division of the Department of Correction, where people are allowed to serve the remainder of their sentence on the outside,
Are you the same Jessica Decimito who was placed on community supervision for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on May 23rd, 2019 for a term of 5 years? Is that you?
All right, so you heard that she was placed on probation for a term of 5 years back in 2019. All right, that's another thing to keep in mind. Sometimes people believe that the plea is in their best interest. Sometimes people may take a plea for a very extended term of probation, 5, 6, 7, 8 years of probation in order to not go to the Department of Correction. However, getting that second chance is not always the gift that it seems, because sometimes a person is given that second chance and they do have a mess up, and it may cause them to have an additional charge along with the revocation. All right, and then they will have to definitely go back and potentially sit in the Department of Correction. All right, let me see, was there anything I want to look up? Let's take a look at probation in TX in Texas. All right. All right, in Texas, probation is called community supervision. All right, it allows offenders to serve their sentences in the community instead of jail or prison. All right, we talked about that. All right, types of probation. You have deferred adjudication. That's where the court defers the conviction and places the defendant on probation. If completed successfully, the case is dismissed without a formal conviction. Now, this is a good program when a person gets into this. A lot of times in some states, they call this the First Time Offender Act. In my home jurisdiction, it is an act. It's called the First Offenders Act. All right, and it's only given to people who are on their first felony offense, and not in every situation. It has to be requested, and a person has to complete their term of supervision without having any hiccups, without any violations or revocations. And if so, at the end of that, their case or their conviction will be sealed. All right, that means that it will be sort of like how this one is dismissed, except that it simply means that conviction can't be seen by the general members of the public. So basically, there are certain agencies that still can see it, like the feds and like the police, if they're looking for if they're looking at a person's criminal record. But everyone else, it will be sealed away from the general public. All right. You have straight probation. Look, they call straight probation. The defendant is convicted and placed on probation instead of jail. The conviction remains on their record. All right. So the difference between these two, one, the probation will remain on the conviction will remain on your record, meaning that if you go try to obtain new employment, if you have certain licensures that you have to receive, they'll be able to see it. The whole world can find it. All right. All right. They talk about the first-time offenders here. All right. They talk about regular reporting, community supervision, restitution, all those types of things. All right, certain conditions while people are on probation. Look at these conditions. All right, we have very similar conditions here in my home state. You might have to pay restitution. You might have to get involved with certain treatment programs and do certain classes. You could have travel restrictions where you cannot leave the state that you are serving probation in, or you can't leave the country. All right. Many times when people receive felony convictions, your passport might be revoked, okay? All right, employment and education. You might be required to get your GED if you don't have that, which is basically the equivalent of a high school diploma if you don't have it. If there's certain violations, then you could be revoked and you might be sent back to jail or prison. There is also early termination. We do that also here in my home jurisdiction. All right, offenders who comply with probation conditions may be eligible for early termination. This is at the judge's discretion and requires a review of the offender's progress. All right. Now remember, if you or a family member or a friend is having any issues with their probation or parole, or if they're getting ready to have a revocation hearing, it's important that people have representation. Here in my home jurisdiction, the public defender is assigned if a person can't afford representation, even at the revocation stage. Okay? All right, with that, let's jump back in. Let's hear what Judge Boyd has to say. Remember, this is in Texas. That's why we're looking at Texas law. And also remember that you can do these same searches. All you have to do is change out what some of my search terms are instead of Texas law, wherever you're looking at. And also, revocations happen on the federal level also, okay? So probation and parole happens at each level of the justice system.
All right, state.
Yes, Your Honor. Violated condition number 2, on or about the 11th day of October 2023 in Bear County, Texas. The defendant, Jessica L. Tesamico, and did then and there admit to illegal use of controlled substance, namely methamphetamine, violation condition number 2.
How do you plead to that? True or not true?
For way to remain violated.
Okay, so you hear that it's not necessary. The pleas are done in a similar fashion that we do in Arkansas. She's asking her, does she plead true or not true to the violation? All right. Instead of pleading guilty or not guilty, it's simply is this simply, has it happened or not? All right. And she has the opportunity to once again take this to a full hearing with the judge, being both the fact finder and the fact finder and the finder of laws, or determiner of what laws are applying there. All right. Usually, when you go to a jury trial, those roles are separated out between two separate sets of people. The judge deals with only the laws. The jury deals with the facts. All right. You're not guaranteed a jury in most states for a revocation, and the reason is because you've already been adjudicated as a convicted, well, I guess in most times a convicted felon or a convicted misdemeanor, but you were allowed to serve your sentence in the community versus serving your sentence in the Department of Correction. So at that point in time, you're not necessarily guaranteed a jury on the revocation stage. All right. And actually, we can do a quick search. So let's do a quick search, and we'll take a look at what that is. All right. In Texas, are you guaranteed a jury for a probation revocation? And I already know the answer is going to be no, but let's see. No jury for probation revocation in Texas. All right, in Texas, you're not guaranteed a jury trial for a probation revocation. Probation revocation hearings are administrative proceedings and are always held in front of a judge. All right, the judge will decide if the state has met its burden of proof regarding the probation violations. The burden of proof in these hearings is a preponderance of the evidence. All right. Remember, when we talk about different burdens of proof, all right, you have preponderance of the evidence, which means more than 50%. So probably 51-49. All right. They don't have to prove so much as when you're talking about beyond a reasonable doubt, or you may have heard of the burden of proof, clear and convincing evidence. All right. Each one of those, this is one of the things they have a metaphor for. I mean, they have not actually sat down and defined how much of a percentage is for each, but they've always been known as you have a scintilla of evidence, which means way less than 50%. That's around 25%. You have by the preponderance of the evidence, which means about 51%. The state has to meet its burden by about 51%. All right, just a majority. You have clear and convincing, which means you need a overarching majority. You need about 75%. Then you have beyond a reasonable doubt, which is probably about 90 to 95%. All right. So, and then you have a standard that we don't use at all here, which is beyond all doubt. All right. So beyond all doubt would mean 100%. That's not used at all in the American jurisprudence system. All right. It may be used somewhere else, and it'd be hard to prove something beyond all doubt. All right. But beyond the reasonable doubt is about 90 to 95%. So it's fairly high. And the only thing that's going to be worthy of causing a doubt is something that would cause a reasonable person to pause in the graver transactions of life. All right. So it has to be something that will really give you pause to say, hey, look, something's wrong here. Something's amiss. but that's not required here for a probation. All you need is just a preponderance of evidence, and remember that means about 51% if you had to give a number to it, okay?
Condition, Your Honor.
Any objections?
No objections.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, sentence you up to 5 years in prison and up to $1,000 fine? Knowing that, do you still wish to plead true to violation of condition number 2?
All right, notice that the author of the video, the court watch people, they put this in, and this is for information because, you know, not everyone is going to have an attorney that's sitting down watching with you all and stopping and explaining different things, or not everyone is going to know how to do this advanced legal research like you're learning here, all right? So he's just giving you some good information. He or she, I don't know if the person here is a he or she who made this, but this channel is giving you some good information. It says defendants caught either by police or probation officers violating condition of probation are subject to having their probation revoked. And they define revoked here as taken away. And all or part of the original suspended jail or prison sentence can be imposed. This is a correct summation of what it means to have a revocation, all right? It's where a person's probation can be revoked. And really, in the criminal justice system, probation it's a privilege, all right? Anyone who's ever been to a prison or been to a jail can ask anyone who's confined in jail or prison, would they rather do their service at home on house arrest or on probation? And I would say a very high percentage of all the people that are incarcerated would say, yes, please let me do my time on the outs and not behind bars. All right? So it's a privilege. All right? And once again, kudos to them. They do give a bit of information as people watch their court videos. All right, let's see what else the judge is going to say. Let's go back and we'll listen again at what she's potentially looking at and what she could face.
Knowing that, do you still wish to sentence you up to 5 years in prison and up to $1,000 fine?
All right, so she's looking at up to 5 years in prison and a $1,000 fine. Let's find out what the felonies in TX, not IX, but TX, and I'm looking for the classifications. All right, that gives us that pulled back the classifications of the different felonies here. I see they even have some state jail felonies here also. They go from 6 months to 2 years in state jail. Now, in my home jurisdiction, anything more than 1 year is considered a felony, and that person would be well, I won't say eligible, but I guess that is probably the term. They'll be eligible to go to the Department of Correction. All right, so we have different levels. We have a capital felony, which is the highest level. It carries life imprisonment without parole or the death penalty. All right, we got first degree. That's anything from 5 to 99 years or life imprisonment, but you do have the opportunity for parole. That's what the difference between first degree and capital. A fine of up to $10,000. Second degree, anything from 2 to 20 years in prison, a fine of up to $10,000. Third degree, anything from 2 to 10 years, and a fine of up to $10,000. All right, so we heard her say 5 years, so we know we're talking about a third degree felony here. All right? All right, let's jump back in.
Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement?
Yes, Your Honor. It is to revoke the individual off the probation, sentence her to 2 years in the Texas Department of Corrections.
All right, is that the agreement?
It is, Your Honor, if I may.
Yes.
Ms. Decimino, I have the honor to represent
Okay, so you hear that there was an agreement that they've come to. That's what a plea agreement is. It's an agreement between both sides, and you know, necessarily it's not a clear win for either side. It's an agreement. Both sides are willing to compromise. Instead of the person saying that I will take this to a full hearing and try to get off scot-free, I will accept a plea. I will accept an agreement, and that way I won't have to go serve the full 5 years. All right, so for the agreement here, the agreement on the table is for 2 years in the Department of Correction instead of serving 5 years. All right, now when a person takes an agreement, as the judge is going to get into here in just a moment, whenever a person takes a plea agreement, one of the things is fairly uniform in every jurisdiction is that if you take a plea agreement that's been accepted freely and voluntarily, then you waive your right to a trial by jury and you waive your right to appeal. All right, so we don't have any trials by jury in a revocation case, but you do have the opportunity to have post-trial, post-hearing motions and the opportunity to appeal. When you accept a plea, you're waiving those rights and you're saying that I will not ask for any post-hearing motions to be heard, nor will I try to appeal this to in this case, the Texas Appeals Court or the Texas Supreme Court to say that there was something wrong with the case.
U.S. Navy veteran. She has suffered from PTSD and some general anxiety, so she's had a struggle with drugs. As we sit here today, we have 844 days credit of Bexar County Jail credit. She's set to expire on her 5-year term.
All right, so you hear she has 844 days of jail credit. Now, I don't know if they actually are making, not that she's been in jail for the 844, but maybe she's getting credit while she's been on probation. And let's look at how many days is that? How many years is 844? All right, that's 2.31 years. All right, so that means she still has a little bit more than 2.5 years left on probation. All right. Understand also that her accepting a plea sort of that stops the judge from sentencing her to whatever she could have received, which was the 5 years. If she's already done a couple of years, it's better to take 2 years in prison, which she won't have to do the full time in state penitentiary, because this is a low level offense. Once again, they need that jail space. They need that prison space for people who are going to commit more heinous crimes. Okay, so in lieu of being punished to 5 years in prison, she took the remainder of whatever her sentence was, 2 years in prison, and then she'll be done. And she'll probably only have to do maybe 50% of that time, so maybe a year, maybe even less. And that's because while a person is in prison, many times in many states have a program, a merit-based program, where if a inmate is good while they're in prison, they receive good time credit and they're able to finish their sentence up faster or become eligible for parole faster.
Here in just 2 months. In May, she's completed her community service hours. She did the parenting class that you requested, Your Honor. We believe, I don't want to talk out of turn, that we are either paid all our money or there's a $70 balance. She's completed with the court's assistance and direction of the DDR program. She's done SAFE-P and she successfully completed that. She's currently a caregiver for her mother. The person that was in her life that helped continue to lead her down a path of challenging ways was her ex-boyfriend that we are glad to report as of July He is a persona non grata. 7/31/2023, she turned him in and they have no further relations. Earlier or late last year, she presented ourselves, and I attended this to herself individually to a 30-day program at Laurel Ridge. She extended it on her own to 45 days.
Okay, so you see, you hear her attorney on her behalf is trying to give the judge as much information as possible about all the good things she did to sort of to mitigate the bad thing, which is the violation of her probation. So he's talking about all the how close she got to finishing, all the programs she did, all the classes she completed like she was supposed to, and we get down to the end of that, and now it's going to be time for the judge to respond back.
All right.
She's a 100% disabled veteran. She works part-time with the gentleman who's here supporting her, Adam Gullen. She does some of the computer work for him. It's been a daily struggle, a challenging, but she's working through this. I think you see on the law program, we're ready to move forward. If you could give her the credit for the time served under this proposal, and we would be honored, Your Honor.
All right. Here's the thing. If I give her credit for time served, with the time she served, which I will, they're going to still take her into custody, and she'll still have to be processed at the prison.
Okay.
All right. If you're drug tested today, what are the results going to be? I'm going to raise your right hand for me, please.
All right. Now you see the judge asked, or the judge informed them that even if I give you all the time served that you're talking about, you'll still have to be processed in by the Department of Correction. Now we've heard already that this is considered an administrative process, and everyone is brought in front of a judge. All right. Same thing if you were actually in the Department of Correction. They have their own hearing officers on that side. They have the Board of Parole, where a person has to go in front of them and determine whether they'll be let out. They have their own grievance forms and things of that nature. All right. The only reason the judge is involved on this side is because she's out in the community still, and you know it's a part of the judge's duties to deal with violations and things that are happening out here in the community. All right. You see that she has asked her, if you were to test today, how would the results turn out? And she answered one way, and then she's making her raise her right hand and be sworn. That's because now, under the penalty of perjury, which is a whole new charge, all right, let's look up perjury in Texas. All right, perjury is considered a serious offense everywhere. That means you lie in court. All right, perjury is a serious offense with significant legal consequences. All right, under the Texas Penal Code, Section 37.02, a person commits perjury if, with intent to deceive and with knowledge of the statement's meaning, they make a false statement under oath or swear to the truth of a false statement previously made, and the statement is required or authorized by law to be made under oath. All right, let's look at what the classifications are. A Class A misdemeanor that's punishable by up to 1 year in jail and a fine of up to $4,000. All right, aggravated perjury. If the false statement is made during or in connection with an official proceeding, all right, and is material, the offense is classified as aggravated perjury, a third-degree felony, punishable by 2 to 10 years in prison and a fine of up to $10,000. That's a fairly serious offense.
Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, can you lower your hand? State your name for the record.
Just all
All right, what are you going to be positive for?
I might be positive in the determination.
All right, so you're still using.
Company, I've actually been abstaining.
All right, so you're, all right, can you lower your hand? State your name for the record.
Just to be this, you know,
All right, what are you going to be positive for?
I might be positioning the code manager.
All right, so you're still using.
Company, I've actually been abstaining. I honestly was cleaning and I found something and I was able to clean up the writings. It's good enough.
All right, that excuse is if you are involved in the court system, you'll hear that excuse all the time. I was cleaning and I ran across an old stash, and instead of throwing it away, I happened to use some. Okay, all right. Look at the judge's face. She's heard this excuse many times before. I hear this excuse all the time. So that's neither here nor there. You accept people as they are, and you attempt to be fair with everyone. All right. All right. Back to what. We'll wind this back, and let's listen to it.
Something and I was able to clean up the writings. It's good enough.
You used it.
Yes, I did.
All right, so.
I did. Sorry.
Well, no, I appreciate your apology, but you really should be apologizing to yourself and your body because drugs do bad things to the body. All right, so this is what the court is going to do. One, you were on probation for 5 years. I can extend you, but you're going to go into custody today and you'll be referred to felony drug court. Yes. All right. Felony drug court is not going to accept you back. So it appears that everything has been tried. I can't think of anything else.
Questions that we also were treatment court. However, back when the referral was made, there were several attempts to get in contact with her and she did not respond.
All right. And so has she been to Safe-P?
Yes.
All right, and once again, I really like how they do things. They have put up the information of what is Safe-P. It's short for SAFPF. Let's throw this into our search over here, and we'll find out exactly what that means. SAFPF. All right, and it's their substance abuse treatment program. All right, it says the Texas Department of Criminal Justice. All right, substance abuse felony punishment facility in Texas. It says the Substance Abuse Felony Punishment Facility is a Texas Department of Criminal Justice, and then here's their acronym, TDCJ, Program for Felony Offenders with Substance Abuse Issues. Here are the key aspects. Number one, the purpose. All right, Safe-P provides intensive substance abuse treatment and rehabilitation for offenders under community supervision or parole. Remember I said we have something here called CCC, and that's 3 letters C, and it's basically just a community, it's a community correction facility program that's sort of like a rehab. All right, they have programs and they have target offenders. People that have drug offenses and people that have certain other offenses can go into one of these facilities for up to well, I guess the maximum term is up to 3 years in CCC here. All right, let's see what it says here. Eligibility. Offenders must be diagnosed with a substance use disorder and have a history of substance abuse. They are typically referred by probation or parole officers. The program structure. They have different phases, phase 1, 2, and 3. All right, phase 1 is an in-prison therapeutic community. Offenders start with a 6-month in-prison treatment program focusing on substance abuse education, counseling, and behavioral therapy. All right, it says that phase 2 is the residential transitional center. After completing phase 1, offenders move to a residential facility for 3 to 6 months, receiving continued treatment and support. All right, so you go from in prison from a prison setting to sort of a halfway house setting. And phase 3 is a reentry court. Offenders then participate in a reentry court program for up to 1 year involving regular court appearances, treatment compliance, and sobriety. All right, you see the treatment components here. All right, the reentry and aftercare. All right, the reentry court program helps offenders transition back into the community with support and accountability. The benefits. It says the SAFE aims, or SAFE P, aims to reduce recidivism by addressing the root causes of substance abuse and providing offenders with tools for drug-free living. The program also offers an alternative to traditional incarceration, focusing on rehabilitation and reintegration.
On the veterans program, we do have a response on that.
Your Honor, during that time frame, I was incarcerated and the Veterans Treatment Program did not accept me. I don't know why, but they did not, and I was incarcerated. They did not respond to me. And
All right, so here's the thing. I see that she's a veteran. I take that in consideration. I see that she has done some things. I know she hasn't lived up to the court's requests. I know that she's continuing to use. I can revoke her. She's going to come out with the same problems. Or I can send her back to SAFE-P, extend her, and counsel if you want to see if Veterans Treatment Court will interview her at the jail, but I won't be releasing her from the jail.
And under the revocation program, would it be a 2-year sanction?
I will follow your agreement for revocation if that's what you all prefer.
Okay, while that's buffering, well, hang on, maybe it's ready to go.
I think,
But either way, she's going into custody.
I think based on the situation with the number of days that she has, that she understands she is still struggling with this on a day-to-day basis. And I think we're appropriate with the 2-year sanction for jail with the credit for time served, if your honor could grant that.
All right. Are you waiving your right to appeal? Are you asking the court to follow this? All right. And I believe she may have used something today or sometime.
Not today. She is very nervous and anxious.
All right, so key point here. If you or a family member or a friend is about to go and accept a plea, don't be intoxicated when you have to appear in front of the judge, all right? That can lead to additional charges or a harsher punishment, all right? Now, notice also what's happening here is that the judge is wanting to send her to SAFE-P. She informed the judge that she attempted to get into a veterans program, but she was not accepted. All right? The judge also said that I will, if you all want, follow the recommendation and do 2 years of incarceration, giving her jail time, and she will have to serve whatever time is left. All right?
In the relationship that I've had with her, there's a very nervous, anxious and nervousness to her personality.
All right. So this is what the court is going to do. I'm going to follow your agreement, grant the motion, sentence you to 2 years in the prison, give you credit for any time served, credit for any inpatient treatment. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it? I'm sorry?
All right, so this, what she's doing now is to make sure that the plea is being freely and voluntarily entered into. All right, that paper that she has there talks about all the rules of what's happening, and also it's required to be signed by her. All right, so it's required to be signed by her, and now she's asking her, has she reviewed that with her attorney? And now she says no, then the judge will then read back over all that right there into the record. And when you say something's being read into the record, it means it's being read out loud and being recorded. And then the person will have the opportunity to either respond yes or no. If they respond no, then they'll just move into a full hearing, and she'll receive whatever punishment that the judge sees fit, as long as it's within the range of time that's still remaining on her original crime or original conviction, shall I say, and not original crime. Okay.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Which branch were you in? All right, so here's the thing, what I know about people who've been in the military. If you're able to go through boot camp, and if you're able to serve, you can beat this, but you just got to be extra vigilant with it. You understand? And if there's anybody out there who's trying to get you off track of being clean and sober, they shouldn't be in your life. And when you're released from the prison, there are plenty of services available for veterans. If something happens and you can't find something when you get out, you can always come back here. If I'm here, you can always come back here to me and we will find something for you. Okay? All right. Thank you so much. Thank you for your service.
Okay, so notice at the end, she said we can go off the record for the rest of this, and that was just some advice that she wanted to give her, and it's basically dicta from the bench. It's not indicative of her case or the sentence. It's simply advice from one person to another. It's well wishes. It's saying that the judge understands her situation, and also saying that she's acknowledging that if you went through the military and boot camp, you should be able to make it through this. And as long as you make it through this, if you ever need assistance when you get out, you can always come back and seek assistance from the court to get you back set up with whatever programs are available for those who have been freed from incarceration. All right. So once again, this video we looked at a revocation, and this is basically a plea bargain that was accepted to accept the punishments from a revocation in lieu of having a full revocation hearing. During the hearing, the state would have potentially put on witnesses that were her probation officers, the drug test that she failed. They would have put that into evidence. They would have taken testimony from her probation officers, and they would have went down her whole record, however many times she's failed in the past, and things of that nature. All right. So I hope that information was helpful for everyone out there to understand what a revocation is. Remember, this case here happened in Texas, so that wasn't indicative of how things are done everywhere. But things operate very similarly in a number of places when we're talking about people that are dealing with parole violations or probation violations, okay? All right, and with that, once again, I am Professor Ross. Thank you for listening. This is Advocacy Alchemy with Professor Ross. And join me for more videos in the future. And if you have time, go and listen to some of the other videos. All right, don't forget to like this video, to subscribe to the channel, and there'll be more information as we move into the future. You all have a good day.